Okay, I think we're 1500 now. So welcome everyone to the Law for Accessibility webinar. It's actually the second webinar that ENIL and ELI have had or will be having. It's a pleasure that we've up to 70 persons who have registered and some great speakers. So we're excited about this meeting. We'll go to slide 2 to explain a bit about how this works. For one, the webinar is recorded, so everybody knows that, and that's why people are mute, so they can't be a lot of background noise. You need to type your name in the chat if you would want to speak, so that we can unmute you and have you speak. If you have a problem, you're supposed to send a message to the host of the webinar at drdn@independentliving.org, or if you have Enos's email at ENIL, which is Enos at, enil.eu. And then we'll share a link to the recording afterwards and write a short report on this. So if we go on to the next slide, was there anything I missed there, and Maria, that's good? Otherwise, it's European Network and the Independent Living Institute, as I said, who are the organizers. I myself am Jamie Bowling. I'm the director of the Independent Living Institute. I was the director for ENIL for some years, and now I'm a board member and co-president, chair of the European Network. After myself, it will be Solina, Griesser or Griesser. I can't say your name. I'm sorry, Solina. I forgot to ask you. I'm always bad about last names. And who will talk about the project itself, Disability Rights Defenders, or what we say DRD. Then there'll be a short introduction on accessibility by Anne-Marie Isbert, who is, practicant. She's with us here in Stockholm for 4 years as a trainee, I guess you would say. Then after that, there'll be a presentation on the High Court case about the right to vote for blind people by Robbie Sino, who's the founder of VVI, or the Voice of Vision Impairment, located in Ireland. The Americans with Disability Act will be presented by Sid Wolinsky, who's a retired chief of litigation at Disability Rights Advocates in Berkeley, California. After that, there'll be a comparative analysis of anti-discrimination legislation with comparing US, Canada, UK, Sweden, and the EU by Paul Lappalainen, a an American and Swedish lawyer. After that, we have the European Accessibility Act, its origin and discussion about differences and similarities between the EAA and the ADA by Inmaculada. Placencia, Porrero, I'm sorry if I say the names wrong, senior expert in disability inclusion at DG Employment, Social Affairs and Inclusion at the European Commission. Then we'll have time for question and discussion, so we won't take them after each person, and then at the end we'll have a closing. Okay, we take the next slide, and I give the voice or the word over to you, Solina. Thank you.
So hello everybody, and welcome to our second webinar. I just take this opportunity to shortly present our project Disability Rights Defenders and our work. So Disability Rights Defenders, DRD, is a network which started in May 2018 by the Independent Living Institute in Sweden. It is funded by Uloba Spente Skansgård Fund, and it's a network where we help each other in using the law as a tool for improving the position of disabled people in society. Because the problem is that even though most countries have ratified the CRPD, the rights of disabled people get violated daily all over the world, and in almost every country there are national laws and international agreements which should assure the same rights for disabled people. So actually on paper it might look good, but in real life we are still far from having equal rights for everyone. Disabled people might not even know their rights, or much less how to use them, for example, in court. So there might be laws, but unless we use them, little will change. The goal of the network is to spread and deepen legal expertise about disability rights, and also to empower disabled people and their organizations to take cases to court. The project enables disabled people and disabled people's organizations, as well as law students, their instructors, lawyers, disability rights advocates, activists, and so on, to interact and consult, meet, and support each other. We do so by bringing these people together in our closed Facebook group, Disability Rights Defenders. That's the name of the Facebook group. And we invite people that are interested in disability rights to join this group and encourage them to share their experiences and methods and advice on how to use the law as a tool to implement and defend the rights of disabled people. In this Facebook group, we welcome contributions in form of brief descriptions of legal cases or court decisions, references to legislation or publications, reports, as well as announcements of events and learning and funding opportunities. Then the content and resources from the discussion on Facebook is summarized in a newsletter a few times a year. Furthermore, we offer webinars like this, open to anybody interested. So if you're not a member of the Facebook group yet, or have not subscribed to the newsletter yet, you can do so through the links that we will send by email after this webinar. So thank you very much for your participation in this webinar and your interest in our work.
Okay, thank you very much, Solina, for that introduction of the DRD network. Let's see, I've lost the PowerPoint for some reason, which means I think we've all lost the PowerPoint. The next slide would be for you, Anne-Marie.
Yeah, hello.
Talk about accessibility.
Can you see the PowerPoint again?
I can't. I don't know if you can, Ines.
Yes, we can see it.
Okay, so maybe it's just mine for some reason. Okay, sorry, go ahead.
Yeah, hello. Today I would like to give you a short introduction into the topic of accessibility and outline a range of it to create a common base on what we are talking about today when we speak about accessibility. So accessibility describes how the built environment is supposed to be designed in order to be open, beneficial, and usable for all people, regardless of any differences. As we are all different, we need different kinds of access which enable us to participate in society. For example, a person with visual impairments would need different conditions to get information from a website. So standardized solutions, which could be seen as equality, do not suit everyone and therefore lead to exclusion of persons. So we need to make sure that access is granted according to individual conditions and needs. There it is where we are starting to talk about equity. The problem is that the environment, services, and informations aren't as accessible as they should be. In fact, there are many barriers out there. These barriers lead to exclusion. So turn it around. Accessibility is an important tool and indicator for inclusion and participation. Inclusion into work, education, and society. To sum it up, the aim of an accessible design is to create an environment in which everyone is included and able to participate. This sounds pretty utopical, right? But actually, access is a human right. Accessibility is named as one of the general principles in Article 3 of the Convention on the Rights of Persons with Disabilities. Article 9 of the CRPD focuses on accessibility and stresses the state party's responsibility to take appropriate measures to ensure to persons with disability access on an equal basis with others to enable them to live independently and participate fully in all aspects of life. That by developing and using universal design, we achieve more accessibility. Universal design means that products, environments, programs, and services should be designed in a way that they are usable by all people to the greatest extent as possible. As I said, to be able to participate in society, we need accessible information, communication, and other services, including technological solutions and emergency services. That means accessibility must not be limited to physical environments like buildings, roads, transports, or other in- and outdoor facilities. Furthermore, one may not forget that stigma, prejudice, stereotyping are also barriers to hold people from being fully integrated. To implement accessible society, we need two approaches. First, changing cultural patterns of interpretation about what is defined as normal. And second, creating an accessible environment in all areas by developing youth-led universal designs, for example. So in today's webinar, Robert Sinnott will present how the right to vote was violated in Ireland because the act of voting was not accessible for people with visual impairments. Later on, we will talk about the North American Disability Act and the European Accessibility Act, and how those acts try to ensure accessibility or the lack of insurance of accessibility. So thank you for your attention. And now Tammy will continue, I think.
Okay, thank you very much, Emery, for the short introduction on accessibility. We go to the next slide. It will be the presentation of Robbie. Please, Robbie, if you want to reintroduce yourself and continue. Thank you.
Thank you very much, Jamie, and hello to everybody. I'm in Dublin, in Ireland, and I realise we have a listener from Kenya, but it's lovely to be speaking to so many people. I was born with a severe visual impairment, and I was sent away to a special school at 4 years of age. In 2009, my sight, what little sight I had, which was less than 3% in one eye, began to deteriorate. And one of the first things I noticed, because it was gradual enough, but I went to vote and I suddenly found I could not vote. And this is a symbolic thing. I mean, we have between 75% and 86% unemployment among blind people throughout the world, but in developed countries. So, I mean, voting but it's very symbolic, because it shows you where you are. You're a second-class citizen if you can't vote. But the Irish law, the Irish system at the time said you can have a trusted friend to vote on your behalf, or else what you can do is ask a presiding officer to vote for you. Now, if I have quadriplegia, that I might be able to use that system. It wouldn't be secret ballot, but at least I could verify that that person has voted exactly the way I wanted them to vote. But having a severe visual impairment, it is impossible to verify that that person has voted according to your wishes. So that would be like, for instance, making a phone call to the polling station and leaving your vote with somebody you don't know and asking them to vote for you, and you don't know what way they're going to vote. It's not just secret ballot. It is just it's the denial of the right to vote in all real senses of the word, because I cannot verify that my vote has been made properly. So that was 2009. In 2010, I founded something called the Blind Legal Alliance with Pat McCarthy down in Cork. And we set to work about, I think one of the first things we looked at was the right to vote. And we engaged with the department, the franchise unit, the relevant department at the time was the Department of Environment in Ireland. And they actually emailed me saying in 2011, saying if I thought they were breaking the law, I should take them to court. So they were very arrogant. Still, I waited for 2 years. I was trying, I was engaging with them, but I wasn't getting much back. 2 years, I was still being ignored, so I decided I would look for legal help. It was very difficult to get legal help, extremely difficult. I had looked in 2012 and couldn't find anybody. But finally, I found somebody in January 2014. They were part of a free legal advice centre in Ireland, which is sponsored by the government. but it has a charity status, but it receives most of its funding from the state. And there was a section in this called Public Interest Law Alliance, PILA, and they said that they would be interested in taking on the case. So what they do is they send around emails to barristers, and they say, we have a case here, would you be interested in looking at this? And a famous case to be taken by PILA as well was Max Schremm, who took a case against Facebook, the secrecy violations that was in Ireland as well. I think that started in 2011. So they were the two very big cases brought by PILA. But so still, I'll fast forward to 2016, and the state was threatening me. The Irish state, I think all states probably do this. When you take them to court, they threaten you because they're afraid if you are successful that other people might might want to sue them as well, which is okay. So, but we were not intimidated by the threats, or I wasn't, and I went ahead and we got a very good barrister, constitutional lawyer. He was former Minister for Justice, and he suddenly spotted, because we had previously thought it was only our constitutional right that was being violated. I have to remind everyone, we cannot take class actions in Ireland like they can in America. We can only take cases as individuals. And this will change because Ireland has recently ratified the UN CRPD, so the Human Rights Commission will be able to, but that will be a long time down the road. I suspect they're not too enthusiastic about that prospect. But anyway, back to the case. I was cross-examined for 4 days because they were trying to undermine me as a person, because they knew there was not much of a case for them to fight. They didn't have much of a defense. So once this happened, and they tried a lot of tricks. My very experienced senior counsel said they had never seen such trickery. I mean, the judge wasn't impressed with their trickery either. And I got a court order in March 2017. And the court order said that the state has to provide, the very good barrister I had was Michael McDougall, and he found it wasn't just constitutional law they were breaking. There was a specific act, 1996 Electoral Act, that gave specifically people with a visual impairment the right to mark their ballot on a ballot paper, to mark their vote on a ballot paper. So it's very specific. It wasn't about computer voting. It was purely about me, or people like me, signing or marking our vote on a piece of paper. So that really suggested one thing, and that was a template, which is, in Germany, they call it a stencil, which I think is a much better word. I think it's a much better word in English even, and it suits it better. But for some reason, the authorities prefer the word template, a ballot template. So I'll call it a stencil for the time because I just prefer it. So the government eventually had to concede that a stencil was, with the High Court order is still there. Now, I was nominated to a work group with the department because of my case victory. And, but strangely enough, we still don't have the right to vote because the conditions aren't right. They provided the stencils, which is very good, but still the ballot papers are too long for the polling booth. And there's a very simple option, which is like an easel, but the state are very reluctant to. They're dragging their heels the full time, even though there's a court order and I could go back to court. They're still very reluctant to make changes. Now, the main reason for this, it's because of who I am. I am an outsider. Now, there are the long-standing charities who the state will always pretend to listen to them and will always say, because they have so much deference towards these people. They're like sacred cows, these old institutions. They originally came from churches and things, but they get a lot of state funding as well. And the state funds them so that they can lobby for themselves to get even more funding. So it's a very circular thing. Now, this is against Article 4.3 of the UN Convention on the Rights of People with Disabilities, as clarified in General Comment 7/13, issued in October 2018. And General Comment 7, paragraph 13, says that service providers a distinction must be made between service providers and what they call people with disability organizations, which is DPO for short, disabled persons organizations. So even if they pack out the board, a service provider packs out the board with people with disabilities, they are still service providers. And the General Common 7 says they have a conflict of interest. So this is, even since we have the court order, we got the court order back in March 2017, the biggest impediment to progress, in my opinion, has been the department's dislike of me because I'm an outsider and I don't have the right credentials. I'm not part of the established authority, the experts in disability. The department still see, and the government still sees, the experts in disability as being people belonging to the traditional organizations who generally do not have disabilities. But they do not see the conflict of interest thing. Now we know that the experts in disability are people with disabilities. We also, when we founded Voice of Vision Impairment in June this year, our basic ethos is that we have to approach every particular issue or problem from the vantage point of the person with the least ability. So that's a challenge to us all. But once we stick with that, that approach, we think we will fit as many people as possible into the universal design. And also the department, we still can't vote yet, as I say, even though I won the case 2 years ago. Now there was another case in England in May 2019, in May this year. It was the Rachel Andrews case, and she won a case against the British government. She was blind. They had stencils in England, in Britain, the United Kingdom. But the problem they had was they didn't have information to go with the stencils. So we still have that problem, but I think finally the department have listened to me and they're going to provide at least an online version of information, which is a start. They had been providing phone information, not by any advice of us. Phone is very difficult because if you ring up and you're trying to listen to, in Ireland, we had 23 candidates in one constituency in the last election. That takes 8 minutes for the phone to read all of them. So somebody's voice just pre-recorded on a phone, it takes 8 minutes. And we have multiple votes in Ireland. So if you want to vote down the list, you could be there for hours. So it's completely impractical. And also you have to hold the phone with one hand, a pencil with the other, and then also with your third hand, you've got to actually read the numbers. And with your fourth hand, you have to check what way you've already voted. So it was completely impractical, but it wasn't, it was purely done by the design of the head of the department responsible for voting, because he thought he was the expert in this case. So again, it's the old adage, nothing about us without us, it comes to. But I'd just like to address one other part when the case was won in 2017. And again, the traditional charities, the main particular charity for blind people in Ireland, they made hay. They made a lot of use out of the victory for their own publicity. And it was very interesting to see the coverage of the case. I mean, there was somebody who hurt their knee and got 20,000 in compensation in Ireland around the same time, and they got wall-to-wall coverage. But this is the most significant case in voting history in the existence of Ireland as an independent state, and there wasn't much interest at all. And I think, again, the disability angle is something, I think I just have to say, if I was a member of any other minority, whether it was whether related to gender, ethnicity, or anything like that, I'm sure it would have made much bigger news. But for some reason, disability, the media are still equally as prejudiced, because they will go to what they think are the quote experts, because that is who matters to them. And it's the easy one-stop shop for them as well. I think in Ireland, because we've only we've only ratified the Convention on the Rights of People with Disabilities in 2018, this is a brand new thing for us. And we're really pushing the door. I mean, it's taking a lot of work. We have 100 semi-state institutions in this country alone and 20 departments. That is a lot of work of convincing to do. We haven't even set up our website yet. We have zero funding. We have nothing coming in. We have nothing going out. And we don't really want to go down the funding model road because we're afraid that we'll lose the authenticity, that we need to keep our ear to the ground. But at the same time, we know that in order to replace, on the visual impairment element anyway, the people who are actively pursuing funds and actively going to our parliament and briefing politicians, they're actually embedded themselves as part of our parliament. The other charities have. So in order to compete with that in terms of campaigning, we campaign because we've no vested interest. We've no economic interest apart from the equality of people with disabilities. But the charities, they lobby because they have a vested interest. As the General Common 7 puts it, a conflict of interest. And I think that is so fundamental to where we are. For me, even though Article 29 of the UNCRPD actively deals with politics and the right to vote, for me, definitely Article 4.3, and in particular, as clarified by 713, is absolutely crucial. It is something we absolutely have to make sure in every single country that the CRPD is implemented. And part of this is the European Disability Forum, who has members that are certainly not DPOs because the majority of their members are service providers. In Ireland, for instance, it's the Disability Federation of Ireland, who have 137 of their 200 members are service providers. And they are the top service providers, disability charities in the country. And that is who's been represented on the European Disability Forum, who have the ear of the European Commission. And we have a long way to go, unfortunately, but I'm up for the journey because we owe it to our dignity. I have taken other cases in law using what we have in Ireland is the Equal Status Act. And but even the websites for taking cases independently there are no longer accessible. So that is another fight in itself. And everything is lack of accessibility is, our major issue at the moment is planning, because the architects and civil engineers have no interest in anything except bicycles at the moment. So I know in Amsterdam or in Copenhagen, in other parts of Europe, for instance, the bicycle is king. But we say the vulnerable pedestrian should be top of the hierarchy. And that we need to be involved from the very beginning in consultation. And that is probably the biggest part of and that may go to law as well, because again, we're quoting law and using law in everything we do. But going back to my case, finally,
2 minutes, Abby, sorry, 2 minutes.
Oh yeah. Just finally, just to say that the case I've taken, I've taken lots of different types of cases, but this is definitely the biggest one, the High Court case for the judicial review. I would do it again, but it is not fair that people, I have to say, we only take cases as a last resort. We take cases because we go to engage with the state and the state ignores us. Now, I have also taken cases against private companies, etc. But we only do it as a case of last resort when there's nothing else. And if for me, apart from the right itself being violated, it really angers me when people just close their ears and just refuse to even engage and to listen. So you feel that the only way that you can have your voice heard is in the courtroom. And that is a bad indictment of the system that we have. Of all the minorities in the world, disability have the longest way to go. And that figures because we have been treated historically and still as subhuman, second-class citizens. And really, it's I don't want to be despondent. I think we are organising in Ireland. People are organising everywhere. And we have to be optimistic, but we have to stand up for our rights. We have to stand up for our dignity. So, and the dignity of those who've even less ability than we have. Because we're the lucky ones to be able to use webinars and things like that. But the people who are at the lowest end, like going back to the 75 to 86% unemployed as well. They need maybe universal income or basic income like they do in Norway for people who are visually impaired, for instance. I'm afraid my knowledge on other disabilities wouldn't be as comprehensive, but we do cross-sectionality. We do have people in wheelchairs in our organization, and we want access for all. And so I don't want.
I'm going to interrupt you there. Sorry, but thank you very much.
Yes, you're very welcome. I was going to
on.
finish there anyway, just to say that hope. We do have hope, and we will get there. That's all.
Showing the good work you're doing. That's fantastic. Thank you for this case. And
Thank
yes,
you.
our voice needs to be heard, and hopefully not only in courtrooms, but from there we need to go on. Thank you again, Robbie, and there'll be time for questions after. And now we will go over to the next slide, and it's the Americans with Disability Act, and I invite Sid to take the floor.
Seems like he is not here.
He's not there. Maybe we hop over Sid and go to Paul. Paul, could you do yours now? And if Sid comes in, we'll take him next and talk about comparative analysis of anti-discrimination.
And if he comes in now, that would probably be a good way to bring in the ADA anyways.
Okay,
I'll
so
start off with a comparative analysis of equality law in the US, Canada, UK, EU, and Sweden. And then the ADA comes in, say, at a later point. Are we ready?
1 second.
Okay, you could skip the introductory slide. You just go straight to the next one. Say this picture with a man on top of a bunch of boxes. It says prejudice, history, sexism, racism, self-image, and denial. Sitting above a bunch of other people, some in wheelchairs, some with different religious attributes, men holding hands, different ethnicities, and him saying, I can't see any qualified applicants. The purpose of that picture is to show, or is to illustrate, at least my view of discrimination, also my view of how discrimination law is developed. If we go to the next slide. And over the years, I've put up the US Civil Rights Act as a key initiator or key inspiration to non-discrimination laws in other countries. As far as I know, the US Civil Rights Act was the first act to come about. And then the UK, there's the 2010 Equality Act, which was actually a consolidation of earlier acts on race, sex, and disability. And you have the Canadian 1977 Human Rights Act, which covered, among other things, race, sex, and disability. And then you have the EU anti-discrimination directives, where race and sex cover working life as well as other areas of social life, whereas disability is only mentioned in regards to working life. And then you have the Swedish 2009 Discrimination Act, which covers race, sex, and disability, among others, as well as covering all areas of social life. If you look at the next slide. Okay, there are some key issues in relation to law. One is constitutional law is an overriding principle. Is particularly important in the US because it became part of the civil rights struggle. In Europe, the Constitution, at least in continental Europe, has not really been used in terms of equality. The words are there, but the lawyers don't bring it up. And then there are other details about equality law that are important: shifting the burden of proof, indirect discrimination, harassment, a government equality body, the idea of public interest law, and lawyers. Then there's also anti-discrimination regarding public contracts and a focus on changing behavior and not just attitudes. Each one of these factors has inspired or has developed in the US and inspired, say, the laws in the other countries, and in particular here in Europe. Next slide. One of the reasons for the big push in the US in regards to race relations or civil rights and discrimination was because of the US history of race relations and the difficulties, the country falling apart, especially during the 1950s due to race relations. But earlier on, civil society had mobilized in the 1910s in regards to, in particular, in regards to the idea of challenging the principle of separate but equal. They wanted to challenge it as being unconstitutional. A legal strategy was developed. As we heard earlier in the discussion, or I thought it was interesting hearing earlier in the discussion about, say, taking the government to court. Governments do not like that. At the same time, that's one way to get respect from the government. It's also a way of mobilizing opinion, mobilizing civil society, even if you lose. In any case, the civil rights organizations and the NAACP Legal Defense Fund in particular eventually ended up getting through the Brown versus Board of Education case in regards to education, which was a key to getting rid of the separate but equal ideas constitutional. And in this way, the civil rights movement laid the foundation for the development of the Civil Rights Act. They developed lawyers from the community, from the Black community in that time. It wasn't just white lawyers, nice white lawyers. They had built up the capacity to bring their own cases and to know which legislation they wanted. And that also meant once the Civil Rights Act was adopted, they were able to push the cases that led to shifting the burden of proof, to indirect discrimination, to harassment as part of discrimination law. Next slide. You also had what I would call a healthy competition between civil rights organizations and public interest bodies, public law interest bodies, as well as the U.S. equality body. This forced both the equality body and the legal defense funds to be more effective because all of a sudden the equality body was not the only game in town. And the case law set the stage for a shifted burden of proof and other factors. The U.S. also provided an inspiration to others on these issues, as well as affirmative action plans, which we have in Sweden, equality bodies, anti-discrimination public contracts. And what's missing in Sweden and Europe is just the idea that civil society needs to develop its use of law. It's not necessarily that you should always be turning to the courts and law in the first instance, but if you have it in as part of your tools, the ability to go to court, that will help other people listen, not just the government, but also private actors. This kind of legal capacity is needed to know so that civil society can know which laws it wants and how they want how they should be formulated. Because asking nice politicians, civil servants to formulate laws that will help you is not necessarily the best way to get those laws. And especially regarding case law, complaining that the equality body is not enough, is not doing enough. It's simply unsatisfactory. Also, if you look at the experience in the US, as well as in Canada, as well as in the UK, civil societies can act on their own and will often have greater trust within the community. Because one thing that's needed for test cases is trust in the lawyers. And quite often lawyers are not necessarily that trustworthy. And that takes time to build up. And at least in Sweden, one of the things that I hear is that, well, civil society organizations, they shouldn't need to go to court, which is fine. They shouldn't need to go to court. Well, one thing I do know is that civil society organizations in Sweden that have power, the unions and the employers associations, they have no problem with going to court. They have no problem with telling politicians what the laws should look like that affect them. And they will go to court to test those laws. But civil society organizations that represent the less powerful are told that you should trust good politicians and good civil servants to deliver what you want. And I don't think that it works. Life works that way. Next slide. In any case, the final picture is about getting rid of the boxes that this guy was sitting on. And the way you get rid of the boxes is by focusing on the boxes and not always going to the guy in the boxes and saying, we're the ones who are in the most trouble, we're the ones suffering the most. He's not necessarily going to react. But if you start attacking the boxes together, then you can bring about change. That's it. Thanks.
Okay, thank you very much, Paul. That was interesting as well. I have a couple questions, but we wait for them afterwards. I saw that Sid had joined us. So we'll ask Sid if you would want to take the floor now to talk about the ADA. Welcome to our to the seminar.
Good morning. When the ADA passed in July 26, 1990, it was not just a single moment in time, but it was the culmination of literally years of work and development of many pieces of legislation and legal drafting, as well as extraordinary work by the disability community itself. What's important to understand is that the ADA was also not the product of a single person or a single organization or a single movement, but of the entire disability rights community in the United States, as well as being helped by others. Okay. It's not attributable to any person or any one idea, but to an extraordinary, absolutely extraordinary movement. Okay. The key to the passage of the ADA, and I'll discuss this a little more in a little more detail in a moment, is that the disability community in the United States adopted the strategies of the American Civil Rights Movement, which had never been done before. So that in addition to the work of lobbyists and lawyers, the disability community participated in sit-ins, in marches, in protests, and in extremely active and aggressive litigation. To understand the passage of the ADA, it's also important to go back a number of years. And probably the key moment is the passage of Section 504 of the 1973 Rehabilitation Act. Okay. That act provided for anti-discrimination for the recipients of federal funds. Now, the reason that doesn't go far enough, of course, is it doesn't cover the entire massive private sector. But it was a giant step forward, and it set the stage for the concepts that later became absolutely critical to the ADA. Okay. The concept embodied in the Rehabilitation Act of 1973 was, of course, that disability was not inevitable and that it did not result from the disability itself, but disability's disadvantages, so to speak, were much the product of discrimination and exclusion. So the second important point in, with respect to Section 504 is that this was the first time in the United States that people with disabilities were treated as a class, not just as people who are blind or people who use wheelchairs or people who have deafness, but there was a recognition that they had common problems of exclusion and discrimination, and therefore their common problems should be treated as a group. Okay? And it was this extraordinary solidarity of the disability movement, and this concept that became so important to the subsequent passage of the ADA. Okay. After the passage of Section 504 in 1973, the next problem was how to promulgate regulations that described in specific detail what consisted of disability discrimination. And that task was given to the American Federal Agency, Health, Education, and Welfare. Okay. So we needed to define the affirmative steps needed in order to begin to end discrimination in government-funded agencies. Okay. The regulations did not issue, right, until May of 1977. And between 1973 and 1977, there was a remarkable nationwide action taken by the disability community. And this is where the protests, the sit-ins took place that ultimately forced the political mechanisms in the United States to respond. The disability community provided a constant bombardment of letters to the White House. And the successful promulgation of the regulations in the ADA began in the, regulations under Section 504 would become the basis of the subsequent provisions of the ADA. Okay. During the 1980s, there was substantial litigation on disability rights, and there also was political movements taking place that subsequently became very important. Most notably, the alliance of the disability community in the 1980s with women's groups and with minority groups. Okay. There also were a couple of other steps that were precursors to the ADA. In 1988, the Fair Housing Act was amended to include disability. In addition, there was a strengthening of the Air Carrier Access Act, which applied to airlines and prohibited discrimination in airlines. The late 1980s, and I'm trying to take this as a timeline, consisted of the disability community coalescing around the Americans with Disabilities Act, and it became the central focus of the disability community. Okay. They actually, in the late 1980s, began drafting the provisions of the ADA. And the critical point was not just the drafting, but the disability community itself not only lobbied in every aspect for the act, but provided the evidence for its necessity. People were asked to document the obstacles put in the way of their ability to go forward and limiting them because of their disability. Hundreds and hundreds of people kept what we called discrimination diaries. Hearings were held public hearings all around the country. Right? And out of that, all right, came a coalition that included groups so widespread that the disability community itself became a political force to be reckoned with. One very important point is that the American disability community made the deliberate decision not to go with one party or another. There's, of course, a temptation to go with the more progressive groups, but instead they solicited support from both of the major political parties. In local communities, the disability community lobbied candidates. At the same time, a team of lawyers and advocates working together began submitting multiple drafts to Congress, and witnesses came from all over the country. All right. Candidates for office were pressed to take a position on the ADA. Okay. A critical notion that emerged during this process leading to the ADA was the notion that no disability group would be left behind. So in addition to lifting the idea of, from the Rehabilitation Act, of treating people with disabilities as a class, politically, the disability community held firm and would not let the ADA be watered down by eliminating a group. I mean, specifically, bearing in mind that this is the late 1980s, there were powerful forces that did not want the ADA to cover AIDS and other traditional groups that did not want the ADA to cover various mental health disabilities. But the disability community held fast against amending the act to exclude any of that, and ultimately came up with an all-inclusive piece of legislation that was remarkable for its sweep. It also, out of those negotiations and the amendment and the process of drafting, began to incorporate concepts that in the Americans with Disabilities Act we're now familiar with, such as the notion of public accommodations, the concept of something being reasonably achievable, the concept that we're very familiar with of reasonable accommodations for people with disabilities. I cannot emphasize too much the extraordinary role of the disability community who spoke of their own experiences with their own disability, and that the extent to which they were limited from being fully educated or fully employed. So the process of reaching success with the ADA, which, as you know, ultimately became law in 1990, even though it was some parts did not become effective for a year or two later, embodied the now familiar 3 parts: Title I, which covers employment; Title II, which covers state and local governments; and Title III, which covers public accommodations. So what are the lessons that we might learn from the experience of the ADA? Okay. The first is that a major piece of legislation like this can only really be the product of years and an extraordinary amount of work. Okay. The second, maybe it should be the first, is that nobody's going to do it for the disability community. It has to be done by the disability community itself. The third lesson that I've referred to is the importance of making a piece of legislation like this cross-disability, covering all disabilities, and therefore marshaling both the political and the moral forces of the disability community. Okay. Another lesson is what we learned from the civil rights movement and the importance of direct political action and such things as sit-ins and letter, which would now be email, and social media campaigns. A fifth, which is one of my favorites, lesson, is the critical role of lawyers. Lawyers were important not only in drafting, but in helping to organize, in doing litigation to protect the ADA and to extend the ADA. I'm proud of my profession, and they did a great job with respect to the ADA. Okay, and a final lesson that can be learned is the importance of trying to cross political lines as much as possible and to make it inclusive. So that I hope that gives you a short. I hope that will be helpful. Hello?
Thank you very much, Sid, for this, for your information about the ADA. It's very inspiring and shows a lot of work that we need to do. But again, I'll ask some questions later and go from you over to Inmaculada on the European Accessibility Act. I've lost the boxes to unmute. I don't know if somebody else has them. Ines, do you hear me?
Yes, I can hear you. I'm just trying to find.
I can't find these.
Inmaculada. It seems she has disappeared. The participant list, just a second.
I'm there.
Oh, yes, yes.
Okay.
I hear you now. Yeah. You can switch your video on as well if you like.
I have tried to do that, but it says that you put me off, so I cannot do it myself. Okay, let me see. Now I can do it, I think. Give me a second. I got a new pop-up. Okay, can you see me?
Yes.
Yes,
Yes.
you can. Thank you. And my boxes came back as well.
Thank you.
Okay. So, how much time do I have? 10?
You have 15 minutes.
15 minutes.
Long in that, so you have 15 minutes, please.
Okay, very good. So, with this presentation, I would like then to do a couple of things. First tried to set up the context in which the European Accessibility Act was developed and explain to you what are the main components of the Act, as well as to provide you the comparison with the US ADA and other pieces of legislation that, in my view, relate more to the Accessibility Act than necessarily ADA. To complete what the previous speakers have said, which when describing the European anti-discrimination legislation and setting, I think it's important to understand that or to know that the Treaty on the Functioning of the European Union contains an article addressing protecting from discrimination persons with disabilities. It says that without prejudice to other provisions of the treaty and within the limits of the powers of the Union, basically, the appropriate action to combat discrimination inter alia on disability can be undertaken. It also says that when defining and implementing its policies, the Union shall aim to combat discrimination. So this set up these provisions in the treaty are very important because they provide the competencies to the EU to act on against discrimination. It is true that in the European Union we can only operate under the competence provided in the treaty, and outside the treaty is for the member states to implement the law to protect, in this particular case, persons with disabilities from discrimination. In addition, the EU adopted the Charter of Fundamental Rights, and it contains also an article, Article 21, on non-discrimination, that says that any discrimination-based inter alia on disability shall be prohibited. And these provisions of the Charter apply when implementing EU law. So the principles of non-discrimination, the basis, the competencies are set in the treaty. It is true also that we have got already legislation addressing discrimination, protection from discrimination in the area of employment, but there is also a proposal from the Commission since 2008 that would provide a general framework on protection from discrimination. And I would like to emphasize the importance of that proposal because for the first time, complementing what is in the directive related to employment, provides that for the equal treatment of persons with disabilities, it's essential to provide two things: accessibility and reasonable accommodation. So this directive, the idea in this directive is to ensure the equal access of persons with disabilities to products and services, and it distinguishes very well the two elements: general accessibility being an ex-ante obligation based on a set of agreed requirements that aim to address cross-disability barriers, and then the provision of reasonable accommodation, which is exposed and is targeted to individuals. It is in this, I'm mentioning this because it is in this context that the European Accessibility Act was written. The idea was twofold. On one hand, to remove barriers at European level for accessibility, for providing access to goods and services. And on the other hand, it was to support the member states into the implementation of the UN Convention on the Rights of Persons with Disabilities. So the departure point was very, very different from the US, where it was the ADA came, as it was very well explained before, as a civil rights issue. We are here in a very different situation, trying to having an implementation of the convention as a trigger. Second, having removal of specific barriers for products and services, and third of all, working into the context of a European market, because those products and services that are put into the in Europe have to obey certain market rules. So in 2009, when we started working on the preparation of legislation of accessibility, we realized also that we were not starting from scratch. There were many different approaches to accessibility legislation in the member states. Some had very technical details on how to make things accessible. Some were really declarations based on protection from discrimination. Some were linked to procurement. Also, there was, from a thematic point of view, it was very, very different. Most of them, but not to say all of them, had got certain accessibility laws for the built environment. Some of them in transport, and a few of them in the area of ICT. The level of detail was very different, from very detailed technical rules to some general principles, and also the jurisdiction. The jurisdiction was different. Some were clearly national competencies, but some of them were also regional and local. So it is in that context that the Accessibility Act was put on the table in order to harmonize accessibility requirements of certain products and services for which, in accordance with EU law, we could demonstrate that there were barriers in the market. And this has had one additional advantage, using the market as the entry approach, is that we could put legislation on the table and it could be approved by the majority of the member states. At this stage, when the directive was proposed, we already had, it was 2015, and we had 7 years of having the anti-discrimination directive being not adopted, because it needed unanimity and some member states were really very much opposed. The Accessibility Act also was proposed in a moment where there is a constellation of European-related already accessibility legislation. We have in the area of ICT, in addition, a web accessibility directive. We have directives or legislation that regulates audiovisual media and telecommunications. We have some legislation related to transport. Some is based on rights, passenger rights, but some is addressing, for example, in the area of rail, accessibility provisions. We also have got legislation, and this is important now because it links to the Accessibility Act, legislation related to procurement and funds, European funds. So before I enter into more detail, comparing to the US situation, I would say that the Americans with Disability Act would be having more or less an equivalent in terms of the aims and the scope with the proposal for the Article 19 directive, so the 2008 proposal. When it comes to the issue of public procurement and structural funds, we would need to compare in the US with Section 508 and Section 504 of the Rehabilitation Acts. And when you look to the content of the Accessibility Act, we would compare or relate, not compare, but relate two other pieces of US legislation that has not been mentioned yet. One is Section 255 of the Telecommunication Act that regulates telephones and telecommunication equipment and so forth. And the other one is the VCAA of the 21st century accessibility legislation that relates more to audiovisual and other elements. But as I said, you cannot have a one-to-one correspondence, because in the Act we are having elements related to funds and so forth. So let me go now a little bit more in detail of what is covered in the European Accessibility Act. First, the Act puts obligations in a number of products. Those are computers and operating systems, ATMs, ticketing machines, check-in machines, telephones and smartphones, TV equipment and digital television services, telephony services and related equipment, access to audiovisual media services, banking services, e-books, e-commerce, basically this is the scope of the Act. When comparing to ADA, we have, if I may, in all my modest, at least have one advantage, and that is that websites related to e-commerce are identified as an area that will have to be services that will have to be accessible. I know that in the US, the coverage of websites, or let's say of the digital world, is still not clear, and there has been some settlements by going to court, but it is not set in, or clearly stated that the ADA covers. Hello? Yeah?
We can hear you.
Okay, myself, so you can, there is an echo now.
We don't.
Okay.
Try again, let's see, because I haven't heard
Take
it.
that away.
Again,
That would be very good, because otherwise I'm hearing myself and it's difficult to speak. Okay, so what the Accessibility Act does is it sets a number of functional accessibility requirements for products and services before they have to be put in the market. It grants the free movement of those products in the whole union, and very briefly, it puts exactly the same accessibility requirements for public procurement and for EU funds. For EU funds, in particular, the structure, for example, the structural funds or public trans-European networks. And what it says in that area is that if you use the accessibility requirements, you will get what we call presumption of compliance with accessibility obligations, which are already included in those acts. I would like to say a couple of words about enforcement and penalties, because this is very important. The Accessibility Act contains a number of provisions, starting with a soft approach to enforcement and finishing with a stronger one. Let me explain. First, the Accessibility Act requires economic operators to declare that their products and services that they are putting in the market are accessible. Then we have got the obligation to member states to have authorities that are going to check those declarations and are able to receive complaints from users and act under those complaints. But they need to proactively check. Third, it allows a person with a disability, a consumer, or an organization, or on their behalf, to go to court, and in cases where the accessibility obligations of the directive are not respected. It also encourages the member states to set up conciliation procedures to solve those issues, but the right to go to court is there. The directive uses typical words, I would say, used in EU law, that when non-compliance is observed, then penalties have to be effective, proportionate, and dissuasive. But it adds one thing that, in my view, is very important. It says that it has to lead to effective remedial actions. At the end, what we want is when a product or a service is not accessible, and that this is identified and this is set, then the idea is not to only to compensate an individual or punish the perpetrator of the one that has not respected the law, but also remedy the action so that the products and the services would be accessible. In in order to facilitate implementation, we have European standards, and there I would compare with the US legislation, with technical regulations in which the details of accessibility are provided. In fact, we have engaged through many years with the US in order to ensure that ICT accessibility regulations, in our case, standards, are coherent, and they would facilitate a coherent implementation. To give you some examples also of other legislation in which is related to the Accessibility Act from the US, I would like to mention also the transportation legislation, which recently has been amended in the US to cover, or recently, it's a couple of years ago already, but anyway, to cover kiosks, so self-service terminals, and websites of transportation. Those two things we have got also covered in the European Accessibility Act. So this is a general overview I wanted to give you, and I am available in case you have some questions. Thank you.
Thank you very much. That was very interesting as well to hear more about the EAA. I have different questions myself, but I'm wondering, can you, Ines, or the others, see if other people have the questions that they would like to ask first? Who's looking at this? Is it Anne-Marie?
I can. What would be good is if people could type in their name into the chat box, and then we will unmute them. They can ask the question.
Okay, so far you have none?
We have some comments which I can read out.
Okay, go ahead.
So, starting from earlier on, sorry, now I can't hear myself. We had a question for Rob, whether he could provide specific references to the cases he mentioned in Ireland and in England. That was the first question.
Could you say that one more time? You broke. So references to the cases that Rob would have given.
Yes, whether he could find specific references for the cases he mentioned in Ireland and England. So case reference numbers. I don't know if he knows them by heart, but perhaps we can share them.
Send them on, yeah.
After the webinar. And then there were different comments. I can start from the latest one from David Lysack. I don't know how to pronounce that, sorry. The EA is very good, but the problem is that because it doesn't cover the physical world. So if you have an accessible ATM in a building with a step, that is not accessible. And maybe there was another one, Ima, maybe you can comment later on. Another comment from someone, Inmaculada pointed out the importance of the EU Charter concerning non-discrimination. It can be pointed out that together with the European Convention on Human Rights, this provides most member states, along with member states' constitutions, an essentially broader constitutional basis for asserting equality claims. This is an area that is currently under development, but should nevertheless, when appropriate, be brought up in cases at the national level. It's more of a comment. There was a comment to Sid's presentation about not siding with any political party. It's a good point now about not siding with a political party or political belief. I think there's the problem here in Ireland and other member states that people with disabilities rights too closely associated with socialism. And there was another comment from Ireland disagreeing that people with disabilities are, I think, the best experts in their rights. I disagree with that. People with disabilities are experts in living with disabilities, but we are not experts in everything regarding to disabilities. I believe these are all the comments that were received in the chat box. And there was another question which came in just now, also from, this one is from Diogo from Portugal. How can we make EAA or other EU directives applicable to all means of transport, and not only to those which are covered by specific directives and technical specifications.
Okay, thank you, Ines. Would somebody like to comment these first comments?
I can address the ones related to the Accessibility Act if you wish.
Yes, please.
Okay, so basically there are two comments. One on relation to the built environment. The built environment is covered by the Accessibility Act in a what we call an optional or voluntary way. This does not mean that you, as a member state, that a member state might decide not to make their built environment accessible. They have to make the built environment accessible according to the Convention on the Rights of Persons with Disabilities. They might decide to do so following the requirements of the Accessibility Act, or do that following national law. But it is covered. It is covered, and they will have to do it because they have signed up to the convention. It is true, as I said at the beginning, that we look to the situation on the built environment, and it is really an area very much regulated in the member states already. It is also true that most of the elements of the built environment which are regulated are those related to physical disabilities, and we have got in the Act also requirements related to other types of disabilities, and that area was less covered. But the Accessibility Act contains provisions in relation to the built environment, but is built in a way that complements what is there at national level. In addition, we are having a European standard on accessibility being developed, and that would complement the situation in the member states. In relation to the modes of transport, again, here, yes, the Accessibility Act covers certain modes of transport, and several aspects of those modes of transport, because it needs to complement already existing EU law. It relates mainly to information, to websites, to tickets and ticketing machines, to self-service terminals. How to cover the others? You would have to do it at this stage at national law, complementing the European law. In particular, the areas that are less, or the modes of transport that are less covered as regional and local transport. That is the situation in relation to that. But let's not forget two important things that are covered by the Act and also by other existing EU law. It is that if member states use procurement in order to set up transport infrastructures or buildings, they will have to be accessible. There is an obligation in EU law that whatever the purchasing authority is buying, that falls, of course, under EU law, if it's going to be used by people, whether members of the public or staff of the contracting authority, it will have to be accessible. Also, the European, the structural funds contains obligations for accessibility of the infrastructures and the services provided. So if a local transport would be built using EU funds, that would be in principle covered if it is procured or it is using EU funds. That's what I would like to say. Thank you.
That was a good and interesting point. Thank you.
Jamie, I can respond. This is Robbie here, sorry, in Dublin. And I can respond to 2 points raised very briefly, one about politics, the other about expertise. Basically, politics-wise, I can't speak for the rest of Europe, but in Ireland, certainly, I work across all political divides, because when you're campaigning, you work with everybody, you have to. And I have to say, I don't recognise that the point that being made there about the disability is an issue of the left. I don't get that at all. In fact, I'm extremely disappointed, probably more so in the left, I think is definitely found more wanting in this country in terms, because it sees things in terms of other social divides. But definitely, I have found in my experience the right-wing parties to be more cooperative. And I am not making a political point here. I think generally speaking though, since left-wing policies economically are about redistribution of wealth, you would expect left-wing parties to be more interested in disabilities, but that is not the case. The other thing is that, there was one other point, expertise. Now that was an opinion that somebody gave, that people with disabilities aren't the experts, that they were only the experts in living with disabilities, but I'm not giving an opinion. When I'm saying that the disabled persons organizations are the experts, I am only saying what it says in the UN Convention on the Rights of People with Disabilities. So if that person's opinion is against the UNCRPD, maybe they should campaign to have our ratification of the UNCRPD revoked. But that's what it says, and I think it's great that it says that. It redresses the power balance.
Thank you very much.
I have a comment on the
Okay, Sid.
observation about appealing to all parts of the political spectrum. In the United States, as we were moving toward passage of the ADA, there was a serious focus on identifying important members of Congress and the legislative bodies that either themselves had a disability or had members of their family that had a disability. And that was a very successful strategy in reaching across political party lines and the political spectrum to get to the personal. And an example of that is Senator Dole from Hawaii, who's an amputee, even though he's a Republican, became an important part of the movement for passage of the ADA. And so I think sometimes focusing on individuals and their families is one way to cut through the political divide.
Thank you for that. I'd have a lot of questions on your talking about how the disability movement was very strong, but I'm not sure I want to go into that right now and bring it over to that side. I'll see if there's any more comments that have come in through you, Ines, or questions.
Yes, there was another question for Ima and one for Sid. So for Ima, while there is some similarity between the US and the EU, as well as national legislation in some cases, what is missing is the capacity of civil society to actually help enforce the laws, such as the EEA. Did the EU consider, for example, a case law fund like the one established in Canada many years ago? Then there is a bit more information about this. In Canada, it is called the Court Challenges Program. It allows for civil society to apply for support for test cases. At least in Sweden, a big problem is the cost risks in going to court, even if you have an extremely good case. And then a question for Sid from Marie from EDF. I have a question to Sid it's about enforcement of the law. He mentioned that in the US, lawyers were very important for litigation of the ADA, and this was successful. However, here in the EU, our legal systems are different, so there are fewer incentives for going to court. There is, for example, no European case law on air passengers' rights for persons with disabilities, and very few case law on international level. How can this be changed? Thank you. And after that, Jamie, you can take a question from Paul. But perhaps let
thank you very much. Yeah, Ima and Sid can answer, then I'll talk to Paul. Okay, thank you.
Well, you're correct that the lawyers and litigation played a critical role in enforcement of the Americans with Disabilities Act. And something I did not mention about that was that, in effect, the presence of the class action in the United States was very important to that enforcement effort. But suits have been brought individually in series of cases, as well as class actions. And I don't know, maybe our lawyers are a little more aggressive in the United States than elsewhere, but it's certainly a critical part of the enforcement process.
Thank you, Sid. Ima?
Yes. Well, in fact, we have not. Oh, sorry, I'm switching this one. We have not considered the development of a capacity fund or a fund for enforcement. But what we are doing is we are providing funds to European level NGOs, and that is to provide capacity building. But we do not have such a fund. What is important, as I said, is that the complaints in the European Accessibility Act, the enforcement and complaints articles allow the possibility of going to court. And this is not the case in all EU legislation, and also not in all US-related accessibility legislation. The issue what we wanted to do here, and it is very important, is to have the complaints being done through or to an independent body from the ones that have to implement. This is very important in accessibility legislation, because quite often in member states, but also international, accessibility legislation allows for complaints to the same body that has the responsibility of implementation. And this has proven in general not to be very effective. It is important that the one that receives the complaints has also some authority over those that have to implement, in order for, in case of non-compliance, for the remedies obligations to be really enforced.
Thank you very much. I think, Paul, we would ask you then for your question.
Yeah, some quick points. Partly the questions were answered in that a court challenges fund was not considered. One of the reasons for me bringing that up is that it's very important in order for legislation to actually be implemented at the national level. I appreciate the idea of having an independent enforcement body, but the problem is, at least in Sweden, the enforcement body, which is called the Discrimination Ombudsman or the Equality Ombudsman, as far as I can tell, the disability movement has no greater trust in the effective work of that body. And if you have no trust in the work of that body, then there's not much point. I think in the last year they brought 4 cases to court. They have over 100 employees. I used to work there. They have a budget of 12.5 million euros per year, and they bring 4 cases. That's not a very effective way of doing things. And that's why I mentioned the earlier history of the civil rights movement. Developing their lawyers, there was no real incentive earlier to bring these kinds of cases. It was when civil society was actually engaged in bringing cases that they were able to also help develop the law, help develop the enforcement mechanisms. Because that's the problem. If you get only an equivalence in theory between, say the US situation and the European situation, that doesn't help much if you don't have the actual enforcement possibilities. And the big difference between the US and Europe, or at least Sweden and Europe, is that, or Sweden and the US, is there is nothing like the disability rights advocates. And somehow there has to be an inspiration to starting something similar. So civil society has its own legal voice. Even if the disability communities should and has to speak for the disability community, it has not always effectively developed the legal avenues for enforcement. And that's where lawyers come in. And hopefully they will be looking more closely at that.
Can I say something to that? Because I think it's an oversimplification to talk about, in particular in the area of accessibility to the US, because there are very important legislation in the US for accessibility, like the Section 255 of the Telecom Act, which basically regulates accessibility of ICT to a large extent, or the Section 508 of the Rehabilitation Act, that do not allow to go to court. So basically, you have to put a complaint to an administrative body which is responsible for its implementation. So when we compare, I mean, we need to be careful not to extend the way in which ADA is enforced to all the other accessibility provisions in US legislation. Similarly, in Europe, we have to distinguish between different pieces of legislation and also different practices and provisions of national law. Some of them we'd like to go to court, some of them not. What for me is very important is that, of course, those that have to, if at the moment comes to get complaints or to judge cases, is that they would have competencies on accessibility. Because you need to understand what is accessibility, you need to know the provisions in order to be able to address a particular complaint in this area. And it is, particularly in the area of ICT, a very complex technical matter. And it's important to that those that put the complaints, but also those who judge the complaint, have the adequate competencies and knowledge and skills to do so.
You also have
our experience in the United States. Actually, I sort of would second the comments from Sweden. Are that enforcement of the ADA would have been absolutely impossible without the intense involvement of both nonprofit disability legal organizations like disability rights advocates, as well as private lawyers. In theory, we have a major government enforcement agency. It's called the Department of Justice in the United States. And in fact, they've been extremely helpful at some periods of time in helping to enforce the ADA. But there are two problems with them. One is they cannot begin to cover all of the issues nationwide that concern enforcement of the ADA and the problems of the disability community. And the second problem is, of course, they blow with the political winds. So when Obama was president, and we had a very active, aggressive Department of Justice enforcing disability rights litigation. And now that Trump, unfortunately, is our president, we're not seeing the assistance from the Department of Justice that we need. But the point I also want to emphasize is that in addition to the disability nonprofit legal organizations that have helped to enforce the ADA, there are literally thousands of lawyers across the United States who have taken on, as part of their some of them are regular commercial attorneys, but as part of their pro bono practice, have taken on major disability cases on behalf of the disability community. And enforcement of the ADA would have been impossible without them.
Thank you, Sid. And Paul, I have a couple of questions. When you talked about, we brought up this idea, the subject that who is the one who's to control. For example, in Sweden, if it's inaccessible, it's usually you would go to the municipality to complain. And the municipality is the one who also is, what did you say, who controls this? So you're going to the same organization who is responsible. How can you change this? Can you change it through a legislation, or how do we go about trying to change that? The one who's responsible for providing, and then the one who's supposed to check on it.
Asking. Who are you asking?
Yeah, anybody who would be able to answer that. I mean, maybe you yourself to start with.
Okay, I'm assuming that there'll be some oversight responsibility giving to the Swedish Equality Ombudsman. That's why I don't think it will be given to the bodies that are supposed to be providing accessibility. But the oversight responsibility will be given to the discrimination Equality Ombudsman. And like I said, since there doesn't seem to be a whole lot of faith in the Equality Ombudsman from the disability community, how are they going to access the knowledge that they need? How are they going to access the complaints that they need? And how are they going to be able to build the cases that they need if there's no trust? And that's why I brought up the point of the need for a healthy competition between civil society, or a complementarity between civil society and the equality bodies, or enforcement bodies, whoever they are. Because there's always a problem with the government agency being entirely responsible for enforcement. Then they will enforce only when they feel like it's necessary. And that's the situation we have today. That's one of the reasons why at least two of the cases that have been brought recently, the dyslexia case was brought by, well, Law as a Tool for Social Change, the association, where three cases were brought around Sweden. One has been won, but that case was not brought by the Equality Ombudsman. And then there was the DHR case about bus accessibility last year. That was another case that was not brought by the Equality Ombudsman, so that civil society had to take it on. But these are new ideas for civil society. And that's why I bring up the idea of maybe the EU could be helping to build capacity. At the same time that it's important to know exactly which kinds of regulations are being developed, but enforcement capacity by civil society is important.
Which Tima said that you did have funding for this, right, Tima? So would it be projects that would try to apply for this funding, or?
What I said is that there is not any specific funding for doing this. That is what I said. In fact, we have been funding certain seminars at the European Law Academy in Trier, in which part of the training has been related to enforcing legislation. And there, the seminars have been attended also by civil society. So not only civil society, but it has been legal practitioners and also civil society, representatives of civil society organization. So while we do not have completely separate funding for that, we have been having some training, some capacity building, and also I know that in the context of the preparation of, for example, the Accessibility Act, we have been doing some studies, getting information, and also we finance the disabilities, a certain number of disability organizations at EU level that uses some of these funds for improving capacity of their members. So I think it's important to clarify the response. Yeah, thank you.
Okay, thank you.
I have a question, Jamie, if possible. Well, just a slight observation first, just that in America, perhaps, this is Robbie here in Ireland again. In America, probably historically, there's more of a philanthropic tradition in that. In Europe, I suspect that most disability groups, civil society organizations are involved in state funding. And like the people getting the most state funding, and the state can give and take funding, but the people getting the most state funding are most invested in the system. And in America, perhaps it's more suitable for civil organizations, etc., to be taking cases because they are outside of the government, outside of the state, and they're not reliant and dependent on them. But my second point is for, I'm sorry, the lady's name from Italy, I forget now, Inmaculada, I can't remember her name, but it was just a question in relation to the European Accessibility Act or Directive 2019. And it's just basically about W3C. It's built very heavily into it. And I see this as being a problem for accessing accessible websites because W3C is an evolving process and it's self-policing. Nobody is an expert on it. And like there are certain people who are volunteering as groups in making this thing up. But we've used it in cases here. Well, the opposition, the state have tried to use W3C because they were getting away with doing very little. And we were able to say that W3C is not worth the paper it's written on because it's basically, it means all things to all people.
Okay. So a couple of things just to start. Well, it is true that for the websites, the Accessibility Act and other European legislation relays on W3C way WCAG 2.0, 2.1, depending which pieces of legislation. By the way, this is also the same, exactly the same case in the US. I would have to disagree with you saying that WCAG 2.0 is not worth the paper. I think it has very important provisions, and I think that the considerable improvement on web accessibility that we have seen is to a large extent due to the work of W3C. Let me also tell you that in addition to relay on W3C WCAG, WCAG 2.0, 2.1, we have got a European standardization system, and in the case, for example, of the Web Accessibility Directive, there are developments to have a common testing methodology, evaluation methodology, and reporting obligations which complement the fact that you have technical standards. In the area of the web, of the web, is particularly important to evaluate regularly because the webs are changing constantly. Their publication of documents is more and more distributed, meaning it's not under control of one person only. So it's indeed a challenge because it's not a static place, to ensure its accessibility. But up to date, I think WCAG 2.0 is one of the most complete and comprehensive documents. The point is, this is a profession, and people need to be trained, and people need to be competent to develop accessibility of websites. It's not enough to, just give a little the standards and then say do it. I mean, you don't do that with architects or engineers. In this case, we also need to have competent people that knows what it means, what WCAG means. So, just to finish, I'm Spanish, not Italian. Not
I'm very sorry.
I like Italian. It's not a problem.
Lo siento.
Okay, no problem.
Em, I have one question. I'm wondering, it's 2015 we have the Act, and I'm wondering, well, what's planned for the evaluation of the Act to see what kind of progress has gone forward?
Okay, so this is an important issue. That is the adoption of the Act was in 2015. Member states have 3 years for transposition and another 3 years for economic operators to apply the Act. So we are 6 years from now to not from 2015, from 2019. Yeah, to apply the Act, and then you will have another 5 years once the Act is applicable, that the first reports and kind of evaluation will take place on its functioning. Yeah, so
does that mean 11 years?
This means 11 years, and there are some exceptions for some particular elements, but in general, in 11 years, we will have the first evaluation.
Okay, that's a long way away.
I know.
But I understand. Okay, thanks very much. Ines, has any other questions come in?
Well, yeah, maybe this one, to take this one first, from Marie from EDF again. It's about financial compensation. I think this is for Sid, yes. So the question is, there is a comparison. So for in the European Union, we have a general air passengers' rights regulation, which deals with delays and cancellations with airplanes. And that regulation foresees a financial compensation. So in case flights are delayed, people can apply for compensation. Now, what she's asking is for the regulation or on air passengers with disabilities, this is not the case. So the question for you, Sid, is whether you think a financial compensation can stimulate complaints and enforcement.
Well, we have a problem, a similar problem in the United States with airline transportation, because airline travel actually on the airplane is not covered by the ADA. And the reason it's not covered by the ADA is that prior to the ADA, there was a legislation called the Air Carrier Access Act. And thinking about disability and disability legislation was in a pretty primitive state at that point. And so the Air Carrier Access Act is a toothless tiger in the United States. Not only can you not get compensation if you're bumped off the airline or there's a problem or they won't carry your wheelchair, but effectively you cannot even get injunctive relief. As a result, there has been virtually no litigation and no enforcement against air carriers in the United States. And there's no question in my mind that if you provided for compensation, it would not only be moral and fair, but it would absolutely enhance enforcement. That continues, unfortunately, to be a problem in the United States.
Thank you very much.
And
any other questions, Ines?
There is one final question from our colleague Frank, and that is to Ima. So he's commenting on the built environment and the voluntary standards. He says that we see that even in the national legislation, built environment standards remain very voluntary and without sanctions for not following them. So recently there was, for example, a report in Belgium that while we have legislation on accessibility, none of the 148 new buildings, so built since 2010, were accessible. So he's basically asking, to make his question a bit shorter, why? Because there was strong support by the civil society for built environment provisions in the Act, both at the European and the national level. Why didn't the European Commission side more strongly with the civil society and basically put more pressure on the member states, blocking the inclusion of the built environment in the Act, rather than waiting for their goodwill?
Okay, let me really reassure you that we did what we could, and we were really pushing for, I was really pushing for a strong built environment provisions, but the adoption of the Act requires at least the majority of the member states, in this case, to agree. And the majority of the member states did not want to have built environments regulated compulsory at European level. Let me tell you one thing that is very important to understand from the Act. this optional provision, this optional provision does not mean you can make the built environment accessible or not. What it says, what it means is you can make it accessible according to our rules, but the obligation for making the built environment accessible comes to the UNCRPD for all the member states. So if they don't do it, then you have the right to go to the UNCRPD committee and follow the procedures there. It's just, it's the same, it's something similar to the reservation that the EU has put in relation to the armed forces in the area of employment. This does not mean we do not do it. It means this is for the member states to do. And it is a fundamental difference because sometimes this is presented as it's optional, member state may do the built environment accessible or not. No, it only that it means is that we cannot impose it because we did not manage to get the support we needed for doing this. But they have to do it because of the convention.
Thank you. That brings us up to this, to the discussion on the UNCRPD, EU laws and national laws. I think maybe a subject for another day and how to actually use all these laws.
There's one final question,
Okay.
Jamie, or comment. Whether anyone has any recent studies on the use of assistive technology to vote in Europe, and if yes, whether they would mind sharing it. So perhaps you can send any to the organizers of the webinar. And one final comment just came in. I just thought I would refer to Inmaculada's comments regarding the 2014 public procurement directives. They clearly state that various equality requirements can be included regarding national public contracts, particularly regarding disability. In implementation at the national level, it will be important that serious sanctions are built into public contracts, such as cancellation of the public contracts or suspension from participation for a few years. And that's the end of the questions, the comments.
Okay, we have just a couple minutes left. Who would want to answer this on assistive technology, or is it something we need to send on later?
Yeah, we can send that. Sorry, it's Robbie in Ireland here. There is no study that I know that it comprehensively looks at every. Now we know this because in 2017, as late as 2017, my legal team were scanning the world looking for such surveys. Now you get companies make various things, especially in the United States. There are loads of systems, technological ones, but the only objective, you get each company selling its own wares, and there's no one size, there's no one system. Australia looks very exciting, but the answer to the question is there is no comprehensive study. Irish, the National Disability Authority in Ireland has a study from 2012 which looks at comparative voting throughout the world. It's probably out of date already. Australia, New South Wales in particular, has 3 different ways of voting for people who are visually impaired, which use assistive technology, and that looks to be very exciting indeed. They've had them; they're well established. But in short, there is no comparative study. So I'm sorry to disappoint.
Are you asking on assistive technology? But what was the question in particular? Only to the
voting.
Voting.
Mm-hmm.
Okay. Mm-hmm.
But I would like to say, Inmaculada, that for instance, there is no mention of NVDA. Like, there are so many different devices that screen reading technology uses. It could be an iPhone, or it could be Android, or it could be Windows. And then on top of that, you've got so many different types of screen readers. And it is very difficult for a developer to get every single one of these, and to keep updating websites, updating versions of Windows, of iOS, etc. So it's very difficult for them to keep on top of it. So the default is to make sure they have it, let's say, in JAWS, which is proprietary screen reading software. And if it works in JAWS, then they're happy because they can show that they've done their best. Whereas NVDA, for instance, is open source and it's free. and they're not particularly interested in that. There's no lobbying, nobody lobbying them from NVDA. So my point is, it's very difficult, but because of that, because it's so subjective, it leaves them less, it gives them more to say, well, look, we've done something. And obviously I can't afford JAWS, it's €1,800 or something, or between 12 and 1,800. So it's just, I think it's a difficult one, and I don't think W3C helped. It could have been much more specific than just applying it to something much more, something so subjective.
Okay, thank you for that information, and thank you to all the speakers for great presentations. I feel like we're only on the surface of so many, on the surface, and we'll need to go much deeper, which hopefully we can do in upcoming webinars again. But thank you to each and everyone. I think it's been very interesting. We do have an evaluation we're going to ask you to fill in. So check your emails to be able to find a link to be able to fill this in. And then we will be sending the recording. After a few days, you'll receive a mail with a link to the recording and then a short report with the presentations. So I think if you haven't sent your PowerPoints, I know you had one, Paul, please send them to the group as well. And then a reminder to, if you want to keep on discussing these issues, join the Facebook group for Disability Rights Defenders, which is growing. So subscribe to the newsletters, which isn't monthly, but it's a few times a year. You'll find the link on the ED's website, independentliving.org. And with that, again, thank you very much, everybody. It's been very interesting. I've learned things, and I have questions which I'll put together and send them out, I think, and then watch for the next webinar, which will probably be in January, I think we were saying. Okay, thank you.
Thank you very much, Jamie. Thank you.
Thank you. I will close the meeting now.
Thank you, everybody.
Anybody have anything else to say there, Ines, the providers? Otherwise, we close.
I will close the meeting. Thank you, everyone. Bye-bye.
Thank you, Paul. Thank you,
Thank
Robbie.
you. Thank you, Jamie. Thank you. Bye.
Bye.
Thank you.